United States v. Miller, 307 U.S. 174 is the site. From 1939 is when the decision was handed down. And you see here, Mr. Gordon Dean argued the cause, and Solicitor General Jackson, Assistant Attorney General McMahon, and Messrs. William Barron, Fred Stein, George Knapp, Marvin Smith, Clinton Barry were on brief for the United States. No appearance for the appellees. No appearance for Jack Miller and Frank Layton. No lawyer for them appeared to argue. No lawyer appeared to argue against the U.S. lawyers, the government lawyers. Mr. Justice Reynolds delivered the opinion of the court, and he writes, an indictment in the district or trial court of Western District, Arkansas, charged that Jack Miller and Frank Layton, quote, did unlawfully, knowingly, willfully, and feloniously transport in interstate commerce from the town of Claremore in the state of Oklahoma to the town of Siloam Springs in the state of Arkansas a certain firearm, to wit, a double-barrel 12-gauge Stevens shotgun having a barrel less than 18 inches in length, bearing identification number 76230. Said defendants at the time of so transporting said firearm in interstate commerce, as aforesaid, not having registered said firearm as required by the NFA and not having in their possession a stamp affixed written order for such firearm as provided by the NFA and the regulations issued under authority of the said act of Congress known as the National Firearms Act, approved June 26, 1934, contrary to the form of the statute in such case made and provided and against the peace and dignity of the United States, close quote. A duly interposed demurrer alleged the National Firearms Act is not a revenue measure, but an attempt to usurp police power reserved to the states and is therefore unconstitutional. Also, it offends the inhibition of the Second Amendment to the Constitution that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So to translate this into plain English, Jack Miller and Frank Layton were arguing that the indictment against them under the NFA for this short-barreled shotgun should be thrown out because the NFA itself is unconstitutional. There was a lot of argument at the time. FDR and his New Deal were having trouble getting their policies through the U.S. Constitution. Much of what they wanted to do was unconstitutional. And so they would use tricks. Like instead of regulating something directly, they would instead put a tax on it and say, well, Congress has the power to tax under the U.S. Constitution. So we're not really regulating the thing. We're just taxing the thing, and that's allowed. And of course, that's exactly what the NFA did. Now, there was a similar law passed at the federal level about narcotics. Before this time, narcotics were lawful. Anybody could have narcotics. Lots of people, in fact, had narcotics at home perfectly lawfully. And it was a state police power to regulate narcotics and similar drugs, not a federal. There's nothing in the federal constitution that says the federal government can regulate narcotics. So what did they do? They created a narcotics act that just taxed the narcotics into oblivion. So it made it a crime to have the narcotics if you didn't pay the tax. Exactly the same model as the National Firearms Act. And for many years, that kind of law was deemed unconstitutional. It was recognized as a ruse. You're calling it a tax, but it doesn't actually raise any revenue because all it does is eliminate the underlying conduct. So you are, in effect, regulating the underlying conduct. And for many years, the U.S. Supreme Court was saying these kinds of tax laws in sheep's clothing, we recognize what they are, and they're unconstitutional. Leading among those U.S. Supreme Court justices who recognized this was Justice McReynolds. For many years, he would find laws like the NFA unconstitutional, laws like the Narcotics Act unconstitutional. But as FDR continued to be president and as he appointed more Supreme Court justices, the percentage of justices who were in alignment with this approach, pretending it's a tax as a way of control, became the majority. And eventually, even Justice McReynolds gave up his opposition of these laws. It just became hopeless from a legal argument perspective.